Okay. Hello, everyone. Thank you very much for joining us today. This is our mentorship and internship program put together by JIIPCC, a firm that I started um, last 2019, yes. And I am very passionate about education. I'm very passionate about continuous learning. Um, so I actually started off as we like to call myself a loner. And so I had to do almost everything myself. And I know that it's not easy for people to do things themselves without really having guidance. And so this platform, it's just serving as a big brother or a big sister or an uncle or an auntie, just trying to hold your hand through and helping you through your journey. We do not promise that we have all the answers, but we will try our best to give advice as much as we can. And also, if we are not able to, we would reach out to others that might be able to provide those answers. So if you ask a question or if you have like a research paper or something that you share with us, if I do not know it, then some other mentors in the group might actually know it. And we will not claim to know everything and then give you something that is not correct. So this is just like the first thing to state. Secondly, I would like to say that, especially in Nigeria, like a lot of people are, not just in Nigeria, I think people are learning. Everybody is learning as they go, and there are like new things that are coming. So I just new things. Let's
We
just
have our activities in temporal.
Okay, so I'll just try to mute people, and then when you're ready to speak, you can just unmute yourself. Yeah, so as everyone is learning and all that, one of the things that might happen is somebody might ask a question on an area of IP where you're not really so knowledgeable about. And so that's the reason why we have mentors that might know those areas, or we can tell you, okay, we don't know this now, but by next week, we might get someone else who is skilled in this area that might come to give you a better view on what you want. So just to start off, I will allow the mentees to introduce themselves. And after the introduction, I will introduce the mentor that is around for now. And then when another mentor comes in, I'll also introduce him so that we know him before we start the presentation. So let's start from Michelle. The reason why I'm starting from Michelle is because Michelle has actually been interning already with me from last year. And I can say that she's an exceptional lady because like she's always writing her assignments, she's always submitting, reaching out to me to know if it's okay to log in for the meeting, etc. So she's very prompt in everything that she's doing and she's passionate about IP. So I'd like her to start the introduction first. Thank you. Michelle.
Okay, my name is Michelle Babasui. I'm a law graduate. I graduated last year and I'm awaiting law school 2021.
Is that
I'm
all?
passionate. I'm very, very passionate about IP. I got introduced to IP first of all in my 400 level for my IP lecture, and since then I have just been interested in it. I did my final year thesis on intellectual property, to be specific, image rights in Europe and in the US, and how it compares to image rights in Nigeria. Yes.
Okay, so how what's your plan, like why are you still doing the
Okay.
internship and what's
Yes.
your plan?
Okay. Yes.
Let's a 2 years plan or
I'm interested in doing an LLM in intellectual property or law and technology or information technology, anything relating to intellectual property, mainly to learn more about the course. I didn't do that much of it in university, and that's the main reason also I contacted Mrs. Juliana, because I spent just 1 year doing like intellectual property in school, and then it didn't really give me all the knowledge I knew I was interested in learning, that I knew was out there that I had not learned. So I contacted her, and I've been learning much more about it, much more about it. I'm interested in doing IP practice, or I will be interested in doing IP practice one day after law school, after hopefully a master's degree.
Okay, okay. Thank you very much. So we can move to Bernice.
Hello, good evening, everyone. Can you hear me?
Yes, we can hear you.
Oh, okay. My name is Bernice Asen, and I'm a lawyer. I was called to bar in 2020. That's last year. Yeah, sorry, 2019. Last 2 years, right? So I'm interested in intellectual property law. Like Michelle, I did my final year thesis in intellectual property law, on copyright rather. So I'm excited to join this because I'm on the quest for knowledge. I'm interested in learning more and, going into intellectual property law practice. Let's see. Thank you.
Okay, so like what is like your plan, like maybe 2 or 5 years plan?
Oh, two, 5 years plan. I actually plan on starting my own law firm by the grace of God before the end of the year. So I'm running with that. Yeah. Thank you.
Okay, perfect. Okay, so I'll be calling on Christina Longe.
Hello, can you hear me?
Yes, I can hear you.
Okay, my name is Juliana Imam. I'm a lawyer. I was called to the bar in 2018. And what really got me interested is on intellectual properties. I think I didn't have the opportunity to do it while I was in the university.
Hello? We're not hearing you again, Christina.
Can you hear me now?
Yes, yes.
Yes, I said I didn't have the opportunity to take the course while I was in the school, and it's an area of law that it's very interesting, and I would really love to specialize in. So I applied for the program for in quest for knowledge, and I think I love your write-ups on LinkedIn. I think that was what got me really interested as well. Your LinkedIn profile, your post on LinkedIn got me really interested in it. So I think
Okay, thank
in the
you.
next, let's say, 2 to 3 years, I really want to be a specialized lawyer in intellectual property. Thank you.
Okay. Do you also want to start up your own law firm, or you would prefer to work with someone?
I don't mind working with someone. I really want to know what I'm doing first before starting my own. So
Okay.
for now, I just want to get knowledge and get the experience that I need.
Okay. Okay. That's fine. Thank you. So let's move to Clarice. Hi.
Good evening, guys. I'm Clarice Mideva from Kenya. I'm a lawyer. I was called into the bar last year.
Sorry, your volume is low.
Maybe that's why I love intellectual property
Hello, Clarice.
that
Sorry,
much, research and learning, and that's how I
sorry,
got
your volume is low. Hello?
to know about this program because I attended a webinar last year and I saw Julia. Yeah. Hello. Yes.
Yeah, so your volume was a bit low. So I was saying that you should try to speak up a bit.
Can you hear me?
Yes, we can. Okay. Probably she would come back later. Tolulope, can you introduce yourself, Tolulope? Okay, if she's not ready, Tony, you can go ahead.
Hello, good afternoon. Can you hear me?
Yes.
Okay, my name is Oluwatoni Adekunle. I'm in 500 level. I'm also doing, I said my intellectual property project is, sorry, my project is on intellectual property. I'm so sorry. And since I did the course in 400 level, it has been something that has been of interest to me. I've always wanted to know more about intellectual property and hopefully get a master's. And generally, my hope for the future is to just be a specialist and to know as much as I can about the course, because it's something I find very interesting. So for now, I'm just trying to learn as much as I can and get like enough knowledge so that my project can be well written. So
Okay.
yeah.
That's fine. Thank you very much. So I don't know if Tolu can speak now or Clarice.
Daddy.
Oh, Daddy. Oh,
Oh,
okay.
yes.
Okay, so who is speaking now?
For the exam on
Present.
Good afternoon, everyone.
Good afternoon.
Sorry. So, as I was saying,
Sorry, I am in a retreat, so that's why I couldn't respond. I'm actually in my office retreat. I tried sending a personal message to Juliana, and I sent a message on the chat. I dropped a message saying I'm in a retreat, but I would be going back into the retreat soon. But let me just introduce myself. Please pardon me. Okay, my name is Tolulope Famoroti. I was called to the Nigerian Bar 2015, and I've been practicing the corporate aspect of law. So I got interested in the intellectual property law when I was introduced to speak on intellectual property. So I thought it while to join the internship program so that I can also gain some knowledge.
Okay, okay. Thank you very much. Okay, so Clarice, please, if you can just speak. Sorry for the interruption.
it's okay. Can you hear me now, or my volume is still low?
No, it's okay. We can manage it.
Hello, can you hear me?
Yes, yes. Yes, we can.
I'm Clarice Mideva from Kenya. I'm a lawyer. I was called into the bar last year, November. I'm an IT enthusiast, and I'm also an artist. So yeah, I love researching and I like learning. So that's how I got to know this program, and that's why I'm here.
Okay. Thank you very much, Clarice. So I'll be introducing our mentors to you shortly. That's Mr. Folarin. Mr. Folarin is like a senior uncle to me, and he has taught me a lot of things in this career. He was the MBA president just last year. He just handed over to someone else who is currently the MBA president. And I can tell you that MBA is not the same without him, because he's a force to be reckoned with. Like, he's a mover and shaker. So I am very excited that he said yes to actually be here. And I know that even if I don't know something in this place, he would actually have the answers to it. And if he doesn't have the answer to it, anybody that you need in this world to give you the answer or the document or whatever, he will make it happen for you. That's who he is. So maybe I'll just allow him to say just something very short, and then I'll introduce our second mentor, and then we can start the presentation. Mr. Folarin, please.
I'm actually looking for the person that you just introduced, Juliana. I would like to meet that person because I have a few questions that I need answering to. Good afternoon or good evening, everyone. Thank you very much for that interesting and very kind and generous introduction, Juliana. So I'm a legal practitioner, an immediate past chairman of MB Abuja. So I'm very happy to hear that many of us here are either lawyers or are on that track. I hope my volume is loud enough.
Yes, sir.
Is it loud enough?
Yes, sir.
Okay. Okay. And I'm also quite excited to see. Juliana gave me a sneak peek to some of the. I don't know if I can say that, but I'll say it anyway. She gave me a sneak peek, some of the reports and write-ups, writings that you guys put in. Fantastic stuff. So I would say very well done. Interestingly, some years ago, many years ago, about 12, 13, 14 years ago, I stumbled on an article online from the early 90s. And in that article, the writer, who is a professor now, was saying that IP in Nigeria is in its nascent stage, and that was in the early 90s. In the late 2000s, people kept saying, oh, IP is new, is nascent. Juliana and I, we had the opportunity to meet with somebody in the judiciary, the leadership of judiciary, and he was saying, oh, IP in Nigeria is still nascent. And I'm asking myself, how long will IP be new and nascent and developing? But I'm very happy. I think 10 years ago, we did not have programs like this. And so I would say big up to Juliana for driving IP awareness, IP knowledge in this way. And also, I think all the interns should also give yourselves a round of applause, because it's a rare privilege to find somebody who is willing to teach, people who will be your opposition or your competitors. And Juliana has taken that role. So I'll say thank you, Juliana, and thank you, guys. Well done. Hopefully we'll have an interesting conversation today.
Thank you, sir. So our second mentor was here, but I think he just stepped out. So we'll start immediately. So the first person that will be making her presentation is Michelle. And it's going to be Michelle because this is not her first time. So what you would do, what we usually do is that you can just share the screen so that we see your write-up. You can then start explaining it. Once you're done with it, then we will just talk about like the things that we feel should be pointed out and all that. And then the next person would also do theirs. So Michelle, over to you.
Okay, so I did a short and I named it one because this will be one of many. Can you see the screen? Can everybody see the screen?
Yes.
Okay. On law, IP, and technology. It was my first time even researching for the relationship between IP and technology, not just law, but then intellectual property and technology. Modern societies create rights in intellectual creations in order to provide incentives to create unknown technologies or to even make improvements in existing technology. And basically, say what we all know about IP, that it may not be the only reason, but then one of the main reasons why we have IP rights, why we have copyrights, why we have patents, why we have why you can protect your designs is for incentives. So, for example, if I am a if I am a maybe I'm a an inventor of maybe technologies, maybe I can use a robot now, for example, or cars. If I see that Mr. A created a car, created maybe the engine of the car is specific to him, or the way the engine works is specific to him, and he can have an exclusive right to the use of that engine in that particular way for a period of time, it will even encourage me more to create my own technology, to create my own car engine, for example. It will serve as an incentive for me to create mine with the knowledge at the back of my mind that okay, if I have this, it's going to be exclusive to me. Yes, I may lose it in years time, but for the period when I do it, it will be exclusive to me. The financial benefits will be exclusive to me. The maybe not only financial now, but the praise I will receive, for example, among my peers will be exclusive to me in that sense. So a person who creates a new technology, for example, will qualify for patent protection and will have exclusive rights to his invention for 20 years. I use the example of a car. I create, for example, maybe electric cars is one of the very new inventions that have come up now. The Teslas, the Priuses, for example. Um, and we know how much, well, we may not know, but the creator of the Tesla, Elon Musk, has become I think the richest man now. I know that's not his only source of income, but it is obvious, it will be obvious to everybody that the creation of the Tesla, just creating an electric car which had not been seen before, has made him a millionaire or now a billionaire now that he is. So if he had created it and then it was open to the public for anybody, any Toyota, any other Honda, any of all these other car creators to just copy his design and create it, he would not have made enough money that as he has made from it now. But because of the fact that he has a patent right in the Tesla, in the technology of the Tesla and the fact that it's an electric car, he has been able to make as much money as he has made. Second paragraph here says the intellectual property laws that are most important to development of technology are patent and copyright laws, as I have stated already. Technology law helps protect the creatives which come up with the ideas and also ensures that the rights concerning also ensures the rights concerning the distribution of their work. So for example, if I maybe I have a software now, for example, I develop a software and the software is obviously mine. I have a copyright in that software. Intellectual property rights is what now protects my software from not being copied in, let's say, a different country where I don't want it to be copied in, and then intellectual property rights, copyright in this sense, gives me exclusive right to that software, for example. And then, okay, I'll give you an example of an author may sign a contract to write a series of hardback novels, but then what if after signing that the contract to write those books, the publisher now wants to release it in ebook form, or the publisher says, okay, let's hire George Clooney, for example, let him record the book into an audiobook form and then let's sell it separate from the hardback series that was written by the author. Because of intellectual property right, because of copyright, the rights that pertain to the author also includes any republication of his or her novel. So whether it's an ebook or whether it's an audiobook form now, for example. And lastly, electronic rights make sure all parties understand how a creative work will be distributed and what percentage of the royalties go directly to its creator. So the same thing I've been saying previously about the financial benefits that go to or that will go to an author, for example, an inventor of a car or an inventor of any other technology. Thank you.
Okay. Thank you very much. Okay, so I think I just have one question. You said that that's in your, I think in your, I don't know if it's your second paragraph or your third paragraph, you talked about patent and copyright being what it's like needed for the protection of technology. So I wanted to ask, what do you think about trademark and industrial design also? How does it protect technology, or does it not? Or so does it also protect technology, or it doesn't?
I actually do. Okay, let me think. Do I have time to think? I actually don't know. Trademark. It may protect the. It can protect maybe the name of tech. Okay, for example, now Tesla.
Yes.
Definitely should be trademarked already. So it protects the name, the brand name of the technology of if it's a company or if it's a brand, for example. Yes. Or maybe
Okay.
the signage of the company, the any symbol or logo that they have.
Okay. So you're right, because that you just make something that is new and you don't also protect the brand name and everything is an issue. Can also be an issue because someone else might not touch the technological side of it, but they might just use the name. So it's good that when you have a product, you have to look at it holistically. What are all the IP protections that I might need to protect this? And then for industrial design, what do you think about that?
Okay, for industrial design, when I was searching for this, what came to my mind was like if it's a machine, for example, now like the drawing of the machine, so the specifications and maybe a particular part of, even going back to the car, how the car looks, how the car looks and how that car differs from how other cars will look, for example. Now, so that can be protected with um, industrial designs or the design of the car.
Yes. So that's it. And then what you spoke about towards the last, I think the second to the last paragraph, that's about derivative works. So that's part of the benefits that authors of copyright or the owners have. They also have the rights to their derivative works. And so if anybody wants to create a derivative work out of a particular work, which is probably if it's a book and then you want to um, change that book to a movie, or you want to change it to an audio book, that's a derivative work. And the underlying copyright of it is still for the owner or the author, so you still have to get their permission
Right.
for it, and
Okay.
that's the essence of copyright.
Okay.
So thank you very much, Michelle. So Mr. Marx came in, so I'll just read his profile and then he can just contribute to this, and then Mr. Folarin will round up on the contribution for Michelle's work. So let me just read out. I actually got to know Mr. Marx from there was a particular job that I had, and when I had that job, I needed to seek guidance from people who were higher than me, and so somebody referred him to me, and I reached out to him, and I can say that he was extremely helpful to me, because some other people that I tried reaching out to made it even more difficult for me. But he was very open, he was very candid, and he was able to put me through on a lot of things. He even sent me some documents, and I'm very grateful for his assistance. And also I reached out to him about this, and he was like, sure, even though the period was short, he was like, don't worry, I'll be there. And I'm so excited that he's here. So Mr. Marx Ikongbeh, sorry if I didn't pronounce it well, is the founder, principal of Everlaw Associates. He works extensively in the field of arbitration, ICT, technology law, and intellectual property. Marx is a facilitator on the annual Information Technology and the Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law courses at the World Intellectual Property Organization Academy, and he is an accredited agent of the Nigerian Trademark and Patent Registry and has conducted IP registration business there since 2010. So thank you very much for joining us, Mr. Marx. Please, can you just say one or two things and then contribute to her presentation?
Yeah, thank you so much, Juliana. I hope you can hear me.
Yes, we can hear you.
Yes, and first of all, let me begin by apologizing profusely that I came in late. I had set my agenda, but somehow I went to see an aunt of mine who gave me a special soup from my part of the country that I had. So I think that kind of made me too relaxed, and I forgot to check my agenda, and that is why. So I was on the way driving, so I'm just getting back into the office, and that's why I joined the meeting late. But it's a delight to be here. Thank you so much for inviting me. And then I was surprised when I came into the meeting and I saw Mr. Folarin Aluko is also in the meeting. I'll talk a little bit more about him before I get into my contribution. But I must first thank you and everyone who is on the meeting. It's a privilege to be joining you guys this wonderful Friday evening. And so thanks so much, Juliana, for your passion for IP. I mean, your passion for IP is palpable and it's very infectious. From when I first, had contact with you, the questions you asked, and the things I've seen you do so far. Thank you so much. I believe what you are doing is really important because why IP in Nigeria has not really simmered down is because people have not taken the high message of IP to break it down, make it simpler, and pass it on to people. In fact, and like I said, I'll talk a little more about Mr. Folarin Aluko and the wonderful work he has also done, in this respect. A lot of times, I and Mr. Aluko and others, in our generation have complained that some of with due respect to them, the older generation in IP have not helped the practice of IP in Nigeria because, to an extent, and like I say, with respect to them, they hoarded knowledge and hoarded the practice of IP. Just a few people, law firms were, the ones historically who were into IP in the country, and those law firms kept it within themselves. So, and what that did is that it has made IP a very isolated thing. It has not made it full stream, mainstream, in a legal practice, and that's not good for IP because the more people are aware of IP, the more activity we have on the IP scene, the more profitable IP becomes for all practitioners involved. But thinking you have cornered the market and you just sit on that little pie, you just become what you call a medium-sized fish in a small river, and you think you are doing something great. Whereas there's a big ocean there, you could go there and become a big fish in a big ocean. So what you are doing, I think, is important. Getting people together, breaking down IP, helping people catch, an understanding of what IP is. And then I'll just say a few things about Mr. Aluko. So Mr. Aluko is, in fact, having Mr. Aluko here, I think you have all that you need already. Because for me, I came into IP, what we call tabula rasa. I knew nothing about IP. I had no idea what IP was when I was in university, for instance. I vaguely heard about trademark. You'd hear maybe a case that talk about trademarks, but I never knew anything really about IP all through my university, all through law school, and it was when I started practicing and then maybe a client would come and then I'll see something about trademark. I'll just approach it from a viewpoint of it's just a registration like registering a business name. Not knowing the nitty-gritty, not knowing that behind that registration, there's a whole body of law, not understanding what the rights conferred by that registration is, what the remedies are for the infringement of that right and all of that. Understanding the basis of that manual process of just going to the trademark registry, giving the money to an officer there, registering a trademark, getting the documents and returning to your client. But people like Mr. Aluko. So Mr. Aluko, actually, I met him at a time where, like I said, I was completely tabula rasa in IP. So I was still saying something as ignorant as I want to copyright my patent. So, having Mr. Aluko, like I say, for you guys, you should count yourself really lucky that he was one of the major people who helped me find my feet in IP, to really begin to understand IP, encouraged me to go back and learn more about IP. And then from every discussion I had with him, I learned a lot, got challenged to go back, read up some more, attend courses and learn a lot more. So Mr. Aluko is by now a grandfather in IP. So please, you guys make all the use of him that you can now, as you have seen him now. Make sure you hold on to him very tight and you don't let him go. So yeah, so I listened to the presentation just made by, I believe, Michelle, right?
Yes.
And yeah, though I didn't catch all of the presentation, but I mean, I was impressed with the way you were able to break it down in very simple terms. And I think that's, like I've said before, and I'll say and say, over and over again, that IP needs to be broken down. IP can be, of course, quite complex and technical, but IP has real life application. So I love the way when she was speaking in her presentation, she spoke about real life things, Tesla and all this. These are industries that are almost built, like, I mean, there's a huge technology part to those industries, but without IP, some of these industries would not survive. So things like electric car, for instance, there's a huge, support that it needs from IP law for the relevant actors to pump in so much money, investing in research and development. The only way they are guaranteed to get a return on investment when they pump in so much money into devising new types of batteries that would sustain a car, new methods of charging the car, and all of that. The only way you are guaranteed to get your money out of all that investment is that there's IP law to ensure that you are not done developing that battery and all of that, and somebody else just comes up, your competitor, and is able to steal that idea and use it and compete with you. That way, you are not getting premium returns on your investment. So that way, people will be discouraged to spend so much time and money creating and inventing new ways of better doing things. So breaking IP down to practical scenarios, I think helps a lot. It makes it more relatable, and it helps us particularly when we now talk to end users of IP services, entrepreneurs, business people, to speak to them in the language they can understand. Because when we start saying the abstract things about IP and using all the legal terminology, it might not simmer down. People don't really get what we are saying. But once you can relate it to some of the practical things that we see, products we see around us, and the importance and the value that IP law, brings to making those products work. For instance, I'll give another example. Another industry that would not survive without IP law is pharmaceuticals, for instance. The pharmaceutical industry is almost exclusively built on, the protection that IP law offers for developing new and improved drugs. Because, it takes a lot of money. It takes, for instance, when a new drug is developed, doing clinical trials alone is very expensive, because, in clinical trials, you have to actually get, at some level, human trials where you get people who are going to sign up to take, maybe, for instance, the COVID vaccine. When it was developed, people had to sign up to say, look, we'll take the risk of taking the vaccine, and then you expose us to the virus, and then we see if it works or if it doesn't work. So you could imagine if anything goes wrong and how much you have to pay those kinds of people, the level of insurance you have to take to just ensure you can pull through that process. So imagine if Pfizer does all of that, and the moment they get the vaccine right and the vaccine works, somebody else just comes up, maybe Ranbaxy or any of the other pharmaceutical companies, picks up the vaccine, reverse engineers it, understands how it was made, and begins to produce and sell at the same time. It would mean that, for instance, Pfizer will no longer be able to say, look, for a shot of our vaccine, you have to pay $500. But if Ranbaxy comes and says, for a shot of ours, pay $300, then Pfizer has to bring their price down, and then that way they are not making premium returns on investment. So, like I said, I just like us to see IP from that viewpoint, from the practical things that IP can do, so that when we talk to people, we try to bring to their, to their attention immediately. This is how important IP is. You have a small business, you are trying to do, maybe a small time business, maybe the lady who sells, hair extensions and other beauty products, and she's getting to a point where, she has a foreign supplier. IP law, for instance, to help her sign, an exclusivity agreement with that foreign partner, and then let them appoint you as their agent to register as the registered user of their trademark in Nigeria. That means no one else can import those products into Nigeria. If anybody else goes to buy those products, even indirectly, not directly from the manufacturer, so far as they have been recognized as their sole operator here in Nigeria, it means you actually have the right to stop the other person from bringing in those products. So when we make it practical, like that, I think it helps people to really understand what IP is about, and then that way they are also able to make the most out of IP. So, Juliana, I think at this point I'll just wrap up here so I don't talk too much. And then if there's any other question or anything specifically, I'll be glad to make more contributions. Thank you.
Okay, sir. Thank you very much.
Yes.
So let's go to Mr. Folarin. Please, can you just say your comments on Michelle's work?
Thank you very much, Juliana. I hope everyone can hear me. I would like to say a big thank you to Michelle for putting this fantastic, interesting presentation together.
Hello, sir. They're not hearing you again.
Can you hear me?
Okay.
Can
We
everyone
can hear
hear
you
me?
now.
Okay, I said thank you very. I was commending Michelle
Yes,
for
sir.
putting this together. But before I go into that, I would like to say a few words about my very good friend, Barrister Marx Ikongbeh. I would urge us not to believe everything that Marx said. Marx, when it comes to, in some instances, tends to go very hyperbolic. But Marx is my Oga at the top. He tries to avoid that title because of palliatives. Marx is my Oga at the top.
No way, sir.
And Everlaw, I believe he was. I've had the opportunity to work on a couple of projects with him, and he's a fantastic guy. He's into tech, very forward thinker, and there's a lot about his last name. There's a legacy a very strong legacy behind his last name. I won't say more than that, but for when you read law reports, you would know better. So I would like to say a big thank you once again to Juliana. I think Max has said everything. That's the problem with having somebody like Max talk for you. You just cover the field, and then there'll be nothing else left to say. But intersection between IP and technology, or law, IP and technology, I think throws up a lot of interesting. That me? Okay, I had an echo. Am I still audible?
Yes, sir.
Yes, we can hear you.
Yes. Thank you, boss. So it throws up a lot of interesting possibilities, especially if you consider the fact that intellectual property as a concept, is fairly or relatively new. Intellectual property as a concept that we know it today, is fairly new in the general body of legal concepts, and then if you also consider the fact that technology too is evolving, we got Web 2.0. Web 2.0 is very new. It's now up to 20 years old, and social media and new tech is built on Web 2.0. So as it stands, we still don't know what the possible interplays are, just on the basis of how these different concepts interact and interplay with each other. Talk less of what new technologies may evolve in the future. But when talking about law, IP, and technology in 2021, one is looking at things like AI, Internet of Things, and so on and so forth. I remember in 2003, I watched a video. A friend of mine showed me a video it was 2002, about a new technology that was going to revolutionize communications. And it was Bluetooth, actually. It was a video about a Bluetooth house. And I remember in those days, I think infrared transfer was the main means of wireless transfer. And then we had this Bluetooth house and everything was blue and all of that. But, taking that concept forward to the Internet of Things, one sees a situation where, everything around you has some kind of access to the internet, and, has voice activation, and, is connected to some kind of database somewhere. All these things are all built on IP. It's not far-fetched. When I watched that video, many years ago, we were all like, wow, wow, wow. And we kept going, wow, wow, wow. But today, it's a reality for many people. I have a box, for example, I've had a box for some years, a set-top box that is voice activated at home. So imagine that I connected, I connected that box, the set-top box to my home theater by Bluetooth. And practically you can, without, getting any of these Internet of Things devices, you can do some basic commands on these boxes. But then what is the means by which this technology can be protected? What is the means by which this technology can be, if you may, exploited, marketed, and so on and so forth? IP rights form that basis today. Though a lot of people argue that IP rights may not be sufficient in their current form, in the sense that copyright developed as a response to the development of the printing press. And, IP has practically spawned all sorts of other types of monopolistic rights. So there's still that growing conversation. And I would like to believe that there's no, I don't think we can, anybody, even Professor Lawrence Lessig, for example, emeritus professor of Harvard, I don't think even he can say that there is a definitive body of knowledge, so to say, conclusive body of knowledge, and that's a better phrase, about, on IP today, because it's still growing. Now, the world is looking at the concept of IP in ancient civilizations, in older civilizations, how the general conception of how the monopolistic tendencies of the West, conflict or can cater to the communalist tendencies of more traditional societies, societies in parts of America, Afro-Asia, so that's Africa, some parts of Asia like India, and even places like what they call them now, the Native Americans. Yes. So we tend to have a more communal approach to some of these, to knowledge and to wisdom and to what you may call intellectual property. So it's not held by the individual; it's held by the community. It's held in trust. Sometimes it's held. Everybody is given the information. There's an interesting quote. We had this conversation with dancers some time ago, and there was this quote that someone brought from a judgment. There's a saying among I forget these people now, from Kogi, the Igbira of Kogi, and that saying is, you cannot truly know us until you can dance our dance. And there are some dances that unless you can dance those dances, you cannot marry a woman from those places, and you cannot conduct a marriage. So the idea is that these cultural expressions, or these unique or traditional knowledge, if you may, or unique sets of intellectual property, if you also may, are held by the community. So it's different from the monopolistic concepts that we have from the West. So I think you have those conflicts still alive. And if you look at movements like copyleft, Creative Commons, and so on and so forth, you would find that there's also that push within, in the West, to share GNU, open source thinking and all that. So I think in terms of the intersections between IP and technology, I don't think we started to scratch the surface. But in terms of the traditional areas, I think you got it: patents, trade, copyright. of course, as Juliana said, there's something to be said about trademarks and industrial designs, but then there's still a lot more. I think one question that we should ask in Nigeria today is whether, and I've had this conversation with Marx several years ago, is an interesting conversation, whether patent law can suffice to protect people, to protect startups in the technology space. So startups, especially in the software development space, whether we can use patent law to provide some kind of protection. These are conversations that we need to start to have, or conversations around. I know you talked about Tesla, and Tesla is now the richest man in the world. And those people there, they are thinking about going to the moon and going to Mars and going to other places. But many people here, in this part of the world, are thinking about what they're going to eat tomorrow. So we should start thinking about how IP can provide solutions to some of our day-to-day problems. I've seen some videos from places like Kenya, so I'm happy that Clarice is here. There are videos from Kenya, and Kenya has used IP in very interesting ways. I remember the old M-Pesa days, when M-Pesa started out, and it's crazy. So I think it's a good conversation. I would say well done, Michelle, for scratching the surface. I think there's a lot more below the surface, and hopefully I look forward to reading more from you and hearing more of your thoughts. Thank you.
Okay, thank you very much, sir. You are very deep. So a lot of things that you shared, those of us that are surface, we've learned a lot. Thank you very much to Mr. Marx. Marx, sorry. Thank you. Thank you very much. So
I told you about Mr. Aluko. So you can see that I was telling the truth indeed.
Don't mind Marx, please.
Thank you very much. Thank you very much. So we'll just quickly move to Bernice. I don't know if you are ready to share your slides.
Hello.
Bernice, are you there?
Yes, I'm here. I can't share my slides.
Okay, Bernice is not. Okay.
Hello. I can't share my slides right now. I could just talk on what I wrote. Yes. Can you hear me?
Okay. You're not able to share your slide?
Yes, I'm not able to do that.
Okay. So you can just talk about what you wrote then.
Oh, okay, thank you. Okay, my report was on intellectual property strategy and the need for intellectual property strategy. Basically, I was talking about the fact that it is one thing to have intellectual property and it's one thing to acquire it. I know people say, oh, I have intellectual property and I've created this stuff, I've created that stuff. But there's one thing to go a step further to acquire such rights. That's true registration. There's also another thing to also exploit it after you've acquired it. And yes, in exploiting intellectual property rights, you need a strategy to know how to, because I know that when you create a particular intellectual property, you cannot totally do everything by yourself. For instance, if I have a if I have a work that I've written and I have published it, I can't make it by myself into a movie. I will need somebody else to come and exploit it or do something else with the movie. And I think that's what they did with a book. I don't know if anybody knows this book, The Secret Life of Baba Shege's Wife, where they granted a right to Ebony Light movie to create, Ebony Light Films to create a movie on it. That's also sharing intellectual property and giving licensing to somebody. But when doing that as a creator of a work, you have to have like a strategy in place. What happens when the royalty is not paid? What happens when the person goes beyond the power you give to the person? A company that is starting up is supposed to have a strategy to do that in case issues come up and when to revoke such rights and all of that. Also, in protecting the rights, the extent to which a particular creator can protect their rights when they give out such licenses. For instance, I use the case in my work. I use the recent case of the movie Lottery, where they said that Ebony Life Films did not acquire the rights, but Premium Times was saying that every employee under them gave up their rights at some point, maybe when they signed their employment contract rather. So those are conversations that people need to have, because a lot of employees sign contracts and they do not know that they give up such intellectual property rights or such rights to their employers. Even employers do not know they are supposed to actually protect themselves and know the essence at which they give their employees rights to deal with their particular work. So that was what my report was trying to talk about. Thank you.
Okay, thank you very much, Bernice.
Yes, thank you.
So I wanted to ask if you know like the distinction between jobs or works created by an employer and a work created by an independent contractor.
Okay, I think the difference is that an employee is under the full service of a particular employer, while an independent contractor is not necessarily under the employment. He was just called to carry out a particular service for the person, for the employer. So I think that's the difference. I can't hear you. Hello? Hello?
Sorry. How does it affect their rights? Like, how does it affect the rights in a particular work when it's created by an employee and when it's created by an independent contractor?
I think that when it's created by an employee, it depends on the contract between the individuals, because maybe at the beginning of the employment contract, the employer told them that you're going to give up some rights, or you're going to, any work you're doing under, when I'm providing a particular service for you, probably I'm providing the working space, I'm providing materials for you, any work you are able to do will be mine. A lot of people do not know this because they just pick up an employment contract and just sign it. They just look at the amount they're about to be paid and just sign. A lot of people don't know. Independent contractor also, most of the time, it depends on the terms of the contract between the both of them on who would have intellectual property rights. So that's
okay. Do we have a section in the Copyright Act that addresses this this particular scenario?
Yes, there is a section, but I do not know the exact section. But I know that the copyright law says that in the course of an employment, when an employee creates a particular work, it belongs to the intellectual property rights belongs to the employee, except they've agreed on a different term entirely.
Okay, what our advice is that as the session is going on, just try and check it up and then type the section in the chat box. That's the section that addresses this employee
Yeah, okay, thank you.
Employer relationship. Thank you.
Okay.
So, Mr. Marx, please, can you just contribute on what she shared, please?
Okay, yeah.
Wow, I love your regalia.
Thank you. I'm in my office. I'm standing in my office as an Igbo High Chief today, even though I'm not from Eastern Nigeria, but I'm enjoying Nigeria overall. Yeah. Okay. Thanks so much, Bernice, for that insightful presentation. I mean, I'm really enjoying this, Juliana. Why I'm enjoying it so much is I love the way each participant is breaking these things down. I mean, I've read the written brief report. I love how brief it is, but at the same time, it's in-depth enough to cover the field. You know? So I believe simplifying IP communication the way this program is doing is critical. I mean, I've really enjoyed it, and I love the way Bernice covered the topic and actually brought out, you know, a real-life, ongoing scenario that helps to highlight the need for an IP strategy.
So I'll just add, a few things to what she has said and just try to bring in some perspectives. So IP strategy is actually very important. And one of the importance of IP strategy is that much even beyond the protective part of an IP strategy is actually the income part, or, let me just, they will say in law that maybe what we call, I think, Estopel, it says it's a sword and it's not a shield. So the good thing about IP and having a good IP strategy is that it's both a shield and a sword. So it helps the company actually to even make revenue, and at the same time helps the company to protect against loss of revenue. But I want to move more towards the part where it helps the company to actually make revenue. Because IP strategy actually is about looking at your IP assets and seeing how best to use them to support your business decisions, to make the most returns on your business. So what that means, from a practical viewpoint, is that a lot of times businesses actually have assets they are not aware of. So I'll give a simple example. For instance, now we all know Coca-Cola in Nigeria, but the funny thing is that Coca-Cola in Nigeria is not produced by Coca-Cola as a company, even though I think that has changed a little now. There's Coca-Cola Hellenic, which is a Greek company originally that has like I don't know what to call it, like a mega franchise with Coca-Cola for certain parts of Europe and and some countries in Africa, including Nigeria. But originally, before Coca-Cola Hellenic came on board, Coca-Cola in Nigeria actually was produced by a Nigerian bottling company, which is a separate company. So to highlight the importance of IP strategy, for instance, is to show that the value of that company, Nigerian bottling company, really did not lie in itself. Neither did it lie in its plants, its equipment, and other things. The value actually of that company lay in the franchise we have to produce Coca-Cola drinks in Nigeria. So imagine that the moment Coca-Cola Hellenic took over that franchise, the very next day, even Coca-Cola Hellenic was incorporated as a new company today, immediately took that franchise, the next day its valuation would have shot through the roof and become a lot, well in excess of, I think, Coca-Cola, the Nigerian franchise, it valued well in excess of trillion naira. So imagine that tells us the value of IP. So just that right to use the trademark Coca-Cola alone is, so it means if today I get that right from Coca-Cola, anything I put that, any bottle I put that mark on instantly becomes a bestseller. So imagine that from the other viewpoint, now that a lot of companies have assets they are not aware of. So they are spending money on the wrong things. So they spend a lot of money locking up their offices every weekend, like a Friday like this, putting a lot of security measures in place to ensure that the physical assets they have in their offices are safeguarded. But it never has occurred to them that the greater harm that they incur as a business is that competitors are imitating their products and flooding the market with cheaper versions of their products, making them to reduce prices to still stay in the market, and at the same time they are losing a lot of goodwill. Because when people use a product that is, when people use a counterfeit product, two things happen. First of all, you, the business, you are losing money because the person who bought a bottle of Coca-Cola for 150, that money should have come to Coca-Cola. But unfortunately, that money has gone to maybe some funny guy who did a counterfeit bottle of Coca-Cola. Now, that is one level of the trouble. But the greater level of trouble is that when that consumer takes that Coca-Cola, he's going to say, the Coca-Cola has become bad these days. So, see how this Coca-Cola I bought today is testing. I won't buy Coca-Cola anymore. And the guy switches and begins to take something else. So that means you see the company has lost two things. You have lost the potential, you have lost a sale, direct money. You have also lost future sales, which is where having an IP strategy becomes important. That you need to really project and understand, what are the IPs I have, what is their value, and how best do I deploy them for maximal input. So sometimes when you do, then part of an IP strategy is to do what's called an IP audit, which is a regular assessment, or periodic, assessment of your IP portfolio, your trademarks, your copyright, your patents, your trade secrets. Very important, trade secrets. Very important, because with trade secrets, the only way trade secrets are protected is through the efforts that the company puts into ensuring that those secrets are not released or are not disclosed, to people, outside of the context of confidentiality. So it means that with trade secrets, for instance, if you don't have an IP strategy, you'll never be able to protect your trade secrets. Because an IP strategy will tell you exactly what protection measures to implement. So things like, things members of staff can do and what they can't do, who has priority to look at certain files and who cannot look at certain files. It's all those things put together that if you go to court for a trade secret infringement suit, you have to present to the court to show the court that, look, we took reasonable measures to protect this trade secret. Yet, despite all these measures we took, this person misappropriated our trade secret. So without an IP strategy, you'd never be able to protect trade secrets for instance. So having an IP strategy is very important. And just to touch on the case that Benny spoke about, the ongoing lottery case. When you look at that case, for instance, and you hear the Premium Times saying something like, we have gotten an assignment, as it were, of all IP produced by our people in the course of their work. Yeah, that's one level of it. But what becomes important here, because even for me as a firm, doing our retreat this year, I was looking through our office policy handbook, and then I noticed for the first time that there was something that was not exactly right in terms of ensuring that any work done by a member of the firm using the firm's resources should belong to the firm. I feel that's what should belong to the firm. And you mentioned the Copyright Act, so I'll let Benny do our homework and get back to us on what the Copyright Act says. But it's an area that is very important that businesses must in advance take measures to ensure that there's a clarity between, because sometimes, like the lottery case now, there's a thin line. Some of the work she did was clearly for Premium Time. Some of the work would have gone beyond the scope. So the question would become, did you do that work using the equipment and materials provided by the company? That would become important. So these are issues that, without an IP strategy, you miss out on, and there's a lot of trouble. Yeah. Thank you so much, Juliana.
Thank you very much, sir. It's very insightful. So, Mr. Folarin, please help us round up on this on a very, very deep level.
When I like winding me. If you wind me up, I'll bust. If you wind me up any further, I'll bust. Okay, I think Bernice you touched on contemporary issues. I think Marx has really tied it together very beautifully. Maybe I would say that there's a lot to be said also. I think the general people think that when you talk about IP, you're talking about, when you talk about an IP strategy, you're talking about it's for a certain class of individuals, a class of companies, big companies, the Coca-Colas of the world. Like Marx very rightly said, the Coca-Cola brand is the biggest brand in the world today, and that was a fantastic example. The only brand that will come close to the Coca-Cola brand might be Jesus. So in terms of, and in terms of a strategy, there's this video, it's on YouTube, you can look it up. I think it's from 2009, but apparently every 10 years, Coca-Cola reviews its brand strategy, for all the Coca-Cola brands. So they are very particular about it. But I think there's also a lot to be said about the small and medium scale businesses that, exist, to oil the wheels of commerce and industry. Many of our businesses don't even think about IP, talk less of having an IP strategy. And I think that's very fatal. Marx talked about finance. I think that's very key. I had a series of conversations with people in finance last year, and we talked about cash flow. We're looking at law firms particularly, and we talked about cash flow. And cash flow has three components. You have investments, you have operations, and you have, what's the third one? You have investments, operations, and finance, so equity. And I think that there's a fourth level. I'm not an accountant, but traditional accounting principle says there are three components of cash flow. But I think there's a fourth, and I think IP is a fourth. And apparently you're supposed to be making your operations money comes from the work you do. Investment comes from putting the profits to work by investing in all sorts of stuff. It could be in the stock market or whatever. And then finance is, you get money from finance when you use the equity of the company to raise capital. But then there's another space, which is IP. IP, I remember when Kodak was acquired by, was it Nokia? When Kodak was acquired by Nokia, Kodak had become moribund, but their IP valuation was over $1 billion. And this was in 2009 dollars, not in 2020 dollars. So the valuation, that's Eastman Kodak, the valuation, the IP valuation of the IP assets of the company can actually be worth much more than the actual physical cash flow valuation of the company. In which case it helps one to leverage on whatever one needs to leverage on. So I think to a large extent that is one gap with regard to small and medium scale enterprises that needs to be filled. And Max mentioned, Max is a big boy. He was in Dubai the other day giving a seminar to the Emiratis. I don't think he's a gunner, but we'll probably find out what club he supports. I think Max is a Chelsea supporter. But when talking about law firms, Abi Max, what football team do you support?
Well, at the moment, I'm kind of a destitute fan. Let's just leave it that way. But I support Man U.
Sounds like a former Arsenal fan.
Well, more like a Man U fan in transition. I'm hoping that we sustain.
So
we don't.
The momentum this season, well, we shall see. So I was saying that law firms are actually, we create a lot of content, and we don't put our mind to it. So when an associate does write an article, who owns the article? Yes, if you look at Section 10 of Copyright Act, I think it deals to a large extent with issues of first ownership, but then it's never really a clean cut and dry situation, So hopefully, I think as conversations like this come out in everyday ordinary language, we should be able to drive the conversation to the average businessman, because I know that most businesses, if they were not importing things and if they did not need an SON, if SON did not make it mandatory to get notice of acceptance, or if NAFDAC did not make it mandatory, or if we didn't have these regulations, many companies would not bother with trademark registration, for example. And I spoke with this influencer, very popular influencer, some years ago. No trademark, nothing. And I'm like, I had this conversation with Max about setting up a trolling company, but we need things like that to actually stimulate, to stir the pool, and hopefully this conversation will filter into the mainstream very soon. I think you're muted, Juliana.
Okay. Thank you very much, sir. Thank you for your contribution, very wise contribution. So Tolu is saying that she has a question, but I want us to keep our questions until the end so that everybody can just quickly present and we get the comments on it. And then towards the end, we can then ask our questions. So I'll be calling on Clarice to just make her presentation. If you're able to share the screen, it would be nice, but if you're not able to, you can just discuss what you submitted.
Okay, can you hear me?
Yes, we can hear you.
Okay, I'll try and share my screen. Okay, so my topic is, can you see my screen? Yes, I hope everyone can see my screen. Okay, so my topic was promoting intellectual property in Africa through research. So the reason why I chose this topic is because these days, innovation is no longer based on discovery. It is based on learning. People are just improving on things that had already been innovated before. Like, because we have open source, we have these databases such as Patents Corp, Google Patents, where where when inventions have fallen in the public domain, people can just pick them up and do research with them and develop other things. We can take, for example, the vehicle. The person who invented the vehicle invented it, then someone else improved on it, brought in a roofless vehicle. Recently, we now have electrical cars, so it's just improvements. And this means that knowledge has now become an input and it has become an output. We have now become a knowledge-based economy. So I put a quote here: knowledge is the source of wealth. Just a minute. Is the source of wealth. Applied to tasks we already know, it becomes productivity. Applied to new tasks, it becomes innovation. And I love this quote because it basically means that we research, we create knowledge, we adapt it, then we transform that knowledge into new technology and new innovation. So we know we have two knowledge systems, the formal and the informal. The formal, where which involves the universities, the science and technology institutions, and the industry, where people go to work, so they learn. And then we have the informal, where we learn from what our great-great-grandfathers used to know. For example, those recipes that our great-great-grandfathers used to make food with, we still have them up to now. So that's indigenous knowledge, that's informal. And research plays a key role to innovation. So without research and development, there is no innovation. And even at this COVID time, we can see how African countries are suffering. So since African countries, most of them, they did not fund R&D institutions, we now have to import the COVID vaccines, we have to import the ventilators, we have to wait for those Europe countries to do the things for us when we can just do these things by ourselves. Another thing is that these innovations, they cannot exist in a vacuum. This is where IP comes in. IP now incentivizes these innovators, and it also encourages them to innovate more. It helps the government to also increase its revenue when it taxes those innovations once they hit the market. It allows them to access new markets outside the countries. It also creates employment, in turn contributing to the economy. There have been studies that have shown that these outputs that come from research are contributors to the economy. For example, WIPO did a research in 2012, and it said that the creative industries in Africa contribute more than 5% to the GDP of some countries, and over 3% to employment of their citizens, which means intellectual property is a big thing. So essentially, what I meant is that without the government funding R&D, there'll be no innovation, and with no innovation, there'll be no economic growth. So that was what I worked on. That was what my research was all about.
Thank you very much, Clarice. And I'm actually excited because I can see that you're passionate about research, and that's something that not everyone that is into IP is interested in. So it's good to see someone that is interested in research. So I just have two questions. Do you know what is the best way of protecting like a collaborative research? So we know that for private organizations or for government organizations, they don't just get one person to do the research. Maybe they get a university to conduct the research, or they get a particular team and all that. So what are the ways to protect that research, especially when it's done by a team?
Okay, for me, I think the best way will be joint ownership, because all of you are contributing to the
to the research. So when you protect it, all of you will own a percentage in that, in the innovation. But mostly, if it's universities, they normally have an IP policy, and inside the policy they stipulate who will own the innovation behind the research, who will do this. So if there's a policy that states who owns and who doesn't, then you go with the policy. But I think a joint authorship is how it might be protected.
Okay, because there was something I was reading, and what I saw there is that people who pay for this research, or people who try to acquire research, they actually prefer to work with when the ownership is not scattered among like a lot of people. So if you have students there, you have trainees there, you have people that are doing it, and it's a joint ownership, so everybody owns it. By the time it's time for them to get license to use that, they might have issues having to go from different sub owners, etc. So what I read was that most people, even if they start with that joint ownership, they work towards transferring the ownership to like a single source, or like fewer people, instead of it being scattered everywhere because of purchase issues, license, assignments, etc. Then I wanted to ask, you're not a Nigerian, but in your country, how does the government really fund research? Because I know that in Nigeria, I'm not sure about the funding of research here, how lively the economy is, or the government is to funding research. But in your country, do they fund research a lot?
In my country, it's just recently that I saw that the government has decided to fund 2%, to give 2% to research institutions so that they can conduct research. But unless I go and research about it, I think they just give certain funds to these research institutions and to these science and technology institutions and universities.
Okay.
Yeah.
Thank you very much.
Thank
Over
you.
to Mr. Marx.
Okay. Thank you, Clarice, for that very enlightening presentation. And much again, just like I've said with everyone else, I'm really impressed with how concepts that could be quite technical and complex, we've broken them down, giving such a brief but yet in-depth summary, more so talking about the research part of IT. Because when you get to the research part of IT, it gets very abstract and sometimes it can become uninteresting. Unlike when you talk of other parts of IT, there's a little bit more action because you can talk about live cases and all of that. But when you talk purely from the research point of view, it's almost a little boring. But you did a good job of really summarizing that in some keywords. I just want to confirm, Clarice, what country are you from?
I'm from Kenya.
Oh, you're from Kenya. Oh,
yes.
That's nice. Okay, wow. I taught you in 2019 and I had a good time. I did a road trip from Kampala in Uganda to Nairobi. So I went through all the places, Mao Summit, Nakuru, then there was, what was the place we came in? I can't remember the name now, but I did a road trip, but it was really interesting. Just into the Rift Valley and really interesting. And I hope I'll have the opportunity of doing that sometime again soon. So thanks so much. Yeah, so just coming to your presentation, I think it's very important what you have highlighted that Africa needs to really go into research if we are going to make the best out of IP. IP is also very political. And I mean, Mr. Aluko said something at the beginning, which I want us to go back to when he spoke about, some of the underlying currents when it comes to IP between more capitalist system, a Western system, which of course by default we operate now, and then the more non-capitalist systems like the communal systems of the socialist countries like like Russia, and then talking about people like Africa. So it means that when it comes to Africans, for instance, our approach to ownership of IP, to monopoly, and some of these things are quite different from what the West typically sees. So because of that, it means that if Africa is going to make the best out of IP, Africa is going to need to really sit back and through research understand what are the unique needs of Africa and how best can Africa come to the table and make an impact in IP. I'll give a practical example. One of geographical indications is one aspect of IP that some people have benefited massively from, and lots have lost massively or have not gained as much advantage as others. Let me give one example. France. France has made so much from geographic indications in the area of wines and liqueurs, champagne, for instance. And I read a research that really blew my mind. What France makes from the sale of bottles of wine and champagne, I think it was the way it was analyzed in a month, is much more than Nigeria makes from the sale of crude oil in a whole year. So it tells us how important this is, understanding. And why is that? Because France understood that it had an advantage when it comes to wines and champagne and all, and liquor. But he understood that its advantage was not so strong as in any part of the world could actually transplant some of these things and it could do well, and they could also become competitors, in exporting wines and all of that. So what France understood was that we need to protect something unique to us. So yeah, they say things like, when it comes to geographical indications, you can only create a geographic indication over a product that is produced from an area, and its unique features are connected to the location, the geographic location where it is produced. So for instance, the climate, the climatic conditions, sometimes the know-how, traditional know-how that has been handed down from generations, make people produce better products. So for instance, you go to parts of Italy, they produce unique cheese that you can't find anywhere else in the world. But it's not necessarily that you can't find it anywhere else in the world. If others were given the time, they would actually reverse engineer and come up with products that could even be superior. So geographic indications helps them to maintain a monopoly. Say, look, no one else can produce their own product and try to use our goodwill. So for instance, the word champagne, you can't use it for any other product. So Apple came out with a phone and called the color champagne color. And the Champagne Association that represents the farmers who produce champagne wrote to them and stop them from getting a trademark on that name, because they believe that word is unique to them, and by that they have maintained a huge advantage. So I want to tie that into Africa to say that, look, if France and some parts of the world have understood how geographic indications can really be an advantage to them, for us it's difficult to catch up with geographic indications. Yeah, African products are good, they are unique and all of that, but we don't really have the capacity industrial-wise to add value to our products to be able to maximize the benefits of geographic indications from them. But one area we have an advantage will be traditional knowledge. So we have, from time immemorial, we have traditional healers who use local herbs found within the locality to come up with cures for people even before Western medicine came into Africa. Now, the other part of traditional knowledge is that just like geographic indications, you can use it to block other parts of the world from exploiting what actually is unique to your own environment and unique to your traditional know-how. So, for instance, the ARIPO has a convention called, I think, the Swakopmund Convention on Traditional Knowledge and Folklore. So, what that will do for Africa, if Africa actually gets it right, is to ensure that people can't just come to Africa, take our traditional knowledge and go monetize it, and we get nothing in return. So, typical example, Hakuna Matata, for instance. That is an African. I don't know if that's Swahili. Clarisse would correct me. I don't know if that's no. I don't think it's Swahili. I think that's from somewhere southern Africa.
Yes, it's Swahili.
But, Disney has Swahili. Okay, so you can imagine. People have made so much money from that. Music and lots of things. People even merchandise it, do T-shirts and Hakuna Matata. But I don't know if Kenya is getting anything really from all of that. But there should be, because, for instance, the movie Frozen 2. I heard there's a tribe somewhere in Norway that the movie is largely based on, and they had to go get their permission, and they paid them really heavy royalties to actually have the rights to portray their culture in that movie. But when they come to Africa, same doesn't happen. They just come, take our culture and just go away with it. So if Africa can actually get it right on traditional knowledge and push that as a tool, that would really help Africa. And of course, this will be research-based. So of course, we need to have research to know when a new drug is produced. That drug is based on some traditional knowledge or some herbs and roots that originate from Africa. Then we should actually go there and study them. There's a convention called the Convention on Biological Diversity that says access to genetic resources. So if you're using genetic resources from a location, you need to actually get the permission and have some kind of profit sharing arrangement with the traditional people who are the custodians of that traditional knowledge. So one good example of that was when the Nigerian Pharmaceutical Research Development Institute developed Nicosan, which was a drug for sickle cell anemia. What they did was that they entered into a benefit sharing agreement with some of the local people who knew the herbs and understood the healing potentials of those herbs before it was commercialized. So that way they were supposed to get some benefits from the commercialization. Unfortunately, it didn't really work out too well because somehow there's some other corporate issues with the company that drove that project. But just underscores the importance that if we do this and get it right, then Africa should gain a lot of benefits from what our forefathers have known all this while and handed down from this region. And then, of course, the important part of research, as I conclude, is that with research now, we should stop this, because there was mystery around traditional African healing, for instance. So women, for instance, are not allowed to know the secret of what the healer is using and all of that. But we need to put that mindset behind us and use research-based knowledge to chronicle what Africans have always known from time immemorial. So when anybody else picks that knowledge and wants to use it, say, look, hold on there. Here's our research paper, for instance. So somebody's trying to get a patent on a cure that's from Africa. You could nullify that patent by showing that, look, there's already a research paper that details this herbal remedy and its effects, side effects, and all of that. So therefore, your patent is not new and novel. So that becomes a bargaining chip. Actually, so look, we have to license, from the African people who know these things so that our drugs can actually sell. So I believe Clarissa has touched on a very important topic that Africans will take up research, when it comes to IP to ensure that we get the best out of IP. Thank you, Juliana.
Okay, thank you very much, Mr. Marx. So I think there is a particular research institute that I just heard recently that is in Nigeria that 2 of the embassies are funding for them to do research on like an area of IP. So I believe that even if the African governments are not really funding this research area, there are some embassies that are hugely funding it because of the business interests that they have. So research is also a very interesting place to look at if you're also trying to consider like an area of specialization in IP, because I know that they are also being funded by some embassies. So let's move to Mr. Folarin. Thank you.
Okay, you guys have said it all. I'll just add, I'd say very, very, very good work on this perspective. I think, just as Mark said, and as Juliana said, the relationship between research and IP is very clear. Of course, in Africa, just a quick one. I actually have had a conversation with the head of a research institute, popular research institute in Nigeria. And that person complained that many of her staff, the researchers who are hired and employed by the institute, this is live, yes? Okay. So there's this concern that in some institutes, the staff do not actually do the research. They're not in a hurry to share their research work because they feel it will go to government, quote unquote, as in better, I'm using air quotes now. The research work will go to government and they will not get anything out of it. And I think that's one of the reasons why research institutes are a little retarded. Retarded in the sense of that, are not growing. There's a stunted growth, if you may. But there is a lot to be said about, I don't know, the relationship between research and IP is like the chicken and the egg. When you ask yourself which comes first, research into new things is encouraged by IP protection, and then of course that now gives birth to more research, and then that looping relationship. So again, well done. Please take. I would encourage everyone to look at the conventions that Marx referred to, the ones on TK and on biodiversity. I think there's a lot to be said about TK, and where I'm currently doing some work with people in an industry, in dance, for example, around TK. And though we're not approaching it from the angle of, we're not using IPRs to enforce or to recognize TK, or in this case, traditional cultural expressions. We're coming from the angle of customary law. And I think that should be an interesting conversation, but there's a lot to be said about traditional cultural expressions and traditional knowledge. So good work again on stimulating. It's an introductory conversation, but I think there's a lot more to be said going forward.
Thank you very much, Mr. Folarin. Thank you for your contribution also. So we'll move to Christina. Hello, Christina, are you there?
Hello?
Yes, we can hear you.
Yes, I'm so sorry. I don't have my presentation now.
Okay, meaning that you don't have a topic to discuss today?
Yes.
Okay, all right, it's fine. Please try to submit your presentation next week on Wednesday so that we can distribute it to the mentors and you can discuss next week.
Okay. Okay.
Thank you. I think there's one more person that has not discussed. Tony.
Yes, good afternoon. Good evening.
Good afternoon.
Okay, so I don't exactly have anything to present. I just want to talk about something that I read on a few days ago because I've not submitted my presentation and I've not done it yet.
Okay.
Okay, so what I read on was intellectual property in relation to the cyberspace. Really, it just basically talks about how the internet has opened up to a world of opportunities for artistic and literary creations because everyone and every industry is going digital. Basically, the internet technologies like digital marketing, e-commerce, e-banking, e-learning, especially in this period where everything is going virtual because of COVID-19. It provides ease of transmission from the creator to the viewer and retransmission from viewers, basically making a creative's work more accessible to the general public. And this is intellectual property protection for cyberspace is very important because there are so many people that can pass a creator's work as his own or might reproduce an image exactly or distort it slightly until it is no longer recognizable by the owner, or a copier may fail to credit the owner. And for an intellectual property owner, the main aim is to benefit economically from his copyright work. So basically, creations like books, online publication, online businesses, they are protected under trademark and copyright majorly. I'm done.
Oh, okay. Okay, thank you.
Yeah.
About cyberspace, I cannot claim to be an expert there, but listening to what you said and the protections that are available. So I want to be sure that I'm not muted. Okay, yes. And the protections that are available, you're right, because like a lot of things now are actually online, and since they're online, people easily move it around and all that. So you might even know things about, you might even know things about, you might even know that, someone is distracting me, sorry. You might even know that this particular thing that you've created is actually protected, but how do you even find the infringers? Because intellectual property makes you the police of your work. So the government is not coming to help you check if someone is infringing your work, except for some of the platforms that have put mechanism in place to know when you are using an infringed work. For example, some of the social media platforms like YouTube, Twitter, etc., and Instagram, when you use another person's song or something, it will just prompt you that this is the work of this other person. So we have some things, some platforms like that, but it's not so easy to even find the infringers, knowing that things move fast. So for example, WhatsApp, how do you know if someone is sharing your work on WhatsApp? You, as in, it's hard to even know that with the encryption thing and all that. So those are just some things. And I know that there are some more advanced countries that are actually putting laws in place and improving on their laws when it comes to cyberspace and their technologies. But I don't know how far Nigeria is in that sense. So I'll just move it on to Max. Please help me take it on from here. Thank you, Mr. Max.
Okay, yeah, thank you. Okay, so just to be clear, Juliana, so you want me to look at the cyberspace part of IP?
Yes, that's what she just discussed, cyberspace and its protection.
Okay, excellent. Yeah, that's a good one, and you've laid a good foundation when it comes to the issue, because Mr. Aluko mentioned this at the beginning, that the internet is evolving, IP law is also evolving, and two of them, there's already there's a crossroad where IP law and technology, the Internet 2.0 have met. And just like I mentioned about certain industries that cannot survive without IP law, technology, cyberspace is one of those places, because cyberspace is almost up until now we have not really gotten clarity on what the legal framework for cyberspace is exactly, because there's still a lot of confusion about what law exactly applies on cyberspace. So the typical scenario is still there. You see some nice pair of shoes, you order the pair of shoes, the store you order from is a UK store. The shoes itself is actually made by a company in Italy. So the guys from the UK take your money and then use DHL, a German company, to ship the goods to you. So something goes wrong along the line. What exactly do you do? Who do you sue? How do you sue them? Where do you sue them? Do you have to go to England? Do you have to go to Italy? Do you have to go to Germany? Can you do it in Nigeria? So all of that becomes a question. So the cyberspace presents really interesting challenges, to conventional businesses. But the good thing about it is that IP law actually has emerged as one of the champions when it comes to protecting people when they conduct business in cyberspace. So I'll give some examples of where IP has been cardinal. So we all know that a domain name actually is crucially important for people. Just the way before the emergence of the internet, what was important to us was actually street address, our addresses, post office boxes or street addresses. So in those days, people wanted to reach you. They had to look for your get an address book, maybe get your phone number, a landline, or get your post office box, or get, of course, your physical address and come there. But we know that the current world we live in now, nobody goes through all of that hassle. So they want to get you, they just go, set you up, get your domain, and go to your domain. So a domain name actually, has become a very important piece of identification for businesses online. And because of that, initially there's a lot of confusion. So I mean, what stops me as a lawyer, for instance, from tomorrow going to register a domain www. Let me see. I'm looking at which of the very famous international law firms. So www. What's their name? I wonder. I'm forgetting all their names. Okay, maybe King and Spalding, for instance. So I registered www.kingandspalding.ng. So anybody saying that, say, oh, King and Spalding, the very popular US law firm, now have a Nigerian office, and I could use that. I mean, send that to somebody, send an invoice, and they think they are getting serviced by the famous King and Spalding, and they don't know it's just some funny guy in Abuja who has set them up and takes their money. So remember exactly what I said before. Now, two things happen to King and Spalding. They have lost revenue that have come to them, and they have also lost reputation because possibly they do a poor job of it. And when it's King and Spalding, maybe they have grown too fast and too quick. They have lost quality. I will no longer use King and Spalding. I had a bad experience with their Nigerian office, and then the person doesn't know it's not their Nigerian office. So that became a threat instantly to businesses. Anybody could actually use their trademark to register a domain name, and seeing that trademark, Coca-Cola, for instance, Coca-Cola, www.coca-cola.ng. Anybody is going to quickly watch this. I want to buy some Coca-Cola products. They have a new Nigerian website. Let me see if I can order products there. So it becomes a very important asset to businesses. So, for instance, domain names actually is part of what an IP strategy should capture. What is our domain name? How important is it? What are the hits it gets on the internet? You can use Alexa and those ranking tools to find out, how popular your domain is on the internet. But imagine somebody uses your website to register a domain. What can you do? He's going to be able to get your customers because they're going to think, that refers to you. So one solution that IP immediately produced is, there's an organization called the IICANN, that's the Internet Corporation for Assigned Names and Numbers. That system actually manages the internet system. So let me give just a simple illustration. When I go to my phone book and I want to call Juliana, all I have to set is I'll search for Juliana Imam, and her name pops up, and I dial Juliana Imam. But my phone is not going to be dialing JULIANAIMAM. It will be dialing her phone number, which is linked to her name saved on my phone. So the same thing that domain names do. Computers speak in numbers. So when I go to www.kingandspalding.ng, it's actually a string of numbers called an IP address, a long string of numbers. But just the way you don't memorize everybody's number, it's clumsy. You have to memorize the IP address of every website. So because of that, that's why domain names were created to link a set of words that are memorable, www.kingandspalding.ng, with a long immemorable number that leads to that website. So the corporation that manages this whole system, that creates this linkage between a name and the IP address, is called ICANN, like I just mentioned. So what they did when they noticed this trend was that in 1999, they set up a system called the Uniform Domain Name Dispute Resolution Service. So what that does essentially is that if you have a claim where somebody does what we call cyber spotting, it takes your trademark and registers a domain, and he doesn't own the domain, and he could actually use that to steal your customers. So you just simply approach the UDPR, which is managed by the WIPO. There's a special division of WIPO that manages that, and using that what looks like a court, or is actually an arbitration institution, but just like it's customized, very fast. So in top 6 weeks, you have gotten a final order from them. So if they find that indeed the person who registered the domain has no bona fide right in that domain and is actually using it to defraud, and you have a valid trademark, then they can order immediately that the registrar of that domain should indeed transfer the domain to you. So that's one simple way that IP law has come in to sanitize, doing business in cyberspace. I mean, there's so many other examples, but I'll just stop with this. Thank you, Juliana. You are muted, Juliana. Juliana, you are still muted. We can't hear you.
Okay, sorry. I was trying to unmute my second device. Okay, thank you very much for the illustrations that you gave with WIPO and the department that they have to solve cyber issues, etc. Thank you very much. So, Mr. Folarin, please help us to round up this.
I agree very much with Max on the impact of IP in cyberspace and how WIPO, for example, has actually helped to bring some sanity to that area of the naming disputes. I think, just like I said earlier, the frontiers are ever expanding, and the world has come a long way from the Statute of Anne, which is what is referred to as the first quote unquote IP statute, the first copyright statute. Can we all hear me? Okay. So we've come a very long way. I remember this. I can't remember what his name is now. Sunday Ademi. He launched this book some years ago. He wrote this book and launched it, and somehow he had the bright idea to launch the digital copy on the same day as the physical copy. And then by afternoon of that day, his book had gone viral on WhatsApp. WhatsApp was still fairly new. This was maybe about 6 or 7 years ago. And the book had gone viral on WhatsApp. And everybody was sharing it everywhere. And the man complained, he issued a statement the next day saying people are sharing his book, he's not making money off of it and all that. So that's one way in which technology has affected. Technology impacts IP in the sense that this is a copyright owner who, quote unquote, presumably has been deprived of the benefits of exploiting or selling his work. But then there's another side to that coin. If you look at the justification for what became our distribution system, in Alaba, which was a situation where you had pirates who would tell you, look, instead of us pirating it for you, let us give you some money, we'll mass produce it and sell, And for smaller artists, it was a question of, okay, you know what, I myself on my own, I cannot make 500,000 copies of these CDs. So it had to be like artists will have to do a balancing act. Should I allow these guys to do it or put my music in, all sorts of mixes just so that I can reach, an audience that I would not ordinarily be able to reach on my own. So there's also that question of the far-reaching nature of technology. And let's not forget that technology actually has disrupted many of these traditional systems. So distribution, for example, has been disrupted. I was watching a movie, or I watched a clip actually from a video online recently, yesterday. And it was a clip, there was a video rental club. So it was a clip that was recorded in like a video rental club. And I remembered the video rental clubs of how many years ago. Those businesses are gone today. The music distribution companies, the companies that used to make CDs and mass produce CDs, are almost all gone today, because technology has actually disrupted them. So they definitely will need to have a new conversation around, whether IP is the best medium to protect some of these rights in cyberspace. And I think as we go into 2021, I read some statistics. I came across some statistics last year, and about the growth of e-commerce. And you find that e-commerce is actually where the world is going. The growth has been geometrical in Nigeria. Across the world, it's been geometrical. So you have a situation where two people are doing what you call thrift business, for example, on Instagram. How do they differentiate each other? They use the same pictures. Who took the pictures? You know, these are all IP issues that are thrown up in that space. But again, I think it's good to have this as a starting point for the conversation. So I would say a big well done to everybody who has presented. It would be a good idea if we could look into issues that we raise contemporary issues, but if we could drill them down to issues that touch our daily lives, and touch us on a day-to-day basis, it would really help to personalize, the impact of IP on our lives. So thank you once again for the opportunity, Juliana. It's been a pleasure listening to all the fantastic people here. It's been a pleasure listening to Max as well. Max is my Oga, and I'm coming from my palliative. Thank you very much, Juliana.
Okay, sir. Thank you very much. Thank you to all the mentees for submitting very interesting topics and for presenting intelligently. Thank you to our mentors, Mr. Marx. Thank you so much with your fabulous attire. Thank you for coming and shedding lights on a lot of topics. And then thank you, Mr. Folarin, our uncle up there. Thank you for always guiding us and holding our hands through this IP journey. So I would like just one of the mentees to just say like a vote of thanks to our mentors for today. Any of you can decide to say the vote of thanks. Anybody?
Okay. Mr. Folarin and Mr. Marx, I just want to say on behalf of all of us mentees, we're very, very grateful for you taking out part of your time, coming here to teach us, to give opinions on the things that we have written. I know we didn't have time to ask questions now, but I know a lot of us actually have a lot of questions, and we're happy that we are going to have you in future meetings as well to be able to ask questions of things that we do not understand, ask questions of things that you obviously have gone before us to know and gone before us to learn and everything. So thank you very much.
You're welcome.
Thank you very much.
Okay. Thank you very much, Michelle. Sorry, I was muted. Thank you very much, Michelle, for the vote of thanks. You just talked about questions now, but I'm looking at the time and I don't know if it will be too late to go into questions. So what I'm just thinking is maybe one person can ask the question if there's any question, or maybe if you have a question, you can private chat me. And then, because I'm not sure of WhatsApp groups, if we are interested in that, because not everybody likes it. So if you are interested in a WhatsApp group, you can private chat me so that you can put your questions there and they can respond to me. But if there's one pressing question that's, if you don't ask that question, you might not be able to sleep properly this night, please, I'll just give you a minute to ask it. But if you don't have any questions, then we can just end for today. Okay, so I guess there's no question. Thank you very much, Mr. Marx. Thank you, Mr. Folarin. Thank you to all the mentees. Have a beautiful weekend. And hopefully by Wednesday, you submit your assignments and we meet again on Friday. Thank you very much. Bye.
Yeah, bye. Thank you.
Thank you, sir.
Bye.
Have a good week.
Good night.
Thank
Bye-bye.
you.
Thank you, Ma.
Bye. Thank you, Ma. Bye.
Thank you. Bye.